Wonderful. Good morning, everyone. I'm excited to introduce you to Allan Oziel from the Oziel Law Team. He's joining us today to chat a little bit about commercial contracts and the things that founders need to know about commercial contracts. If you have any questions throughout the session, we are going to take questions as we go, just so if there are things that are specific to your business that you want to ask, that you have the opportunity to ask those questions. You can either put a question in the chat and either Allan or I will kind of jump in and answer that question, or if you'd prefer to raise your hand and come off mute, we can do that as well, whatever works best for you. So Allan, I'll hand it off to you and let you introduce yourself.
Thank you so much, Tabitha. So yeah, as Tabitha mentioned, my name is Allan Oziel, and I am a partner at the law firm Oziel Law. Our firm is a law firm that specializes in primarily innovative startups from their inception, the formation of the business, all the way towards an exit and sort of everything in between. So, including the commercial contracts with a specific expertise on the tech side. We also deal with IP, capital raising, M&A, and we even have a go public practice as well. So it's really, really nice to meet all you. I see a couple people from my team, and I also see one person that's that I've known from the past as well. That's Carlos, who just joined. So nice to have you, Carlos, as well. This is a tough topic, and I think I want to introduce it that way right up front. When I was asked to speak about commercial contracting, we kind of came up with a topic that's commercial contracting with a bit of a skew on the technology side. And then when I got the list of attendees or expected attendees, we saw that the companies really range in terms of the types of businesses that are at Accelerator Centre. Some are obviously software companies, really relevant to some of the stuff that we're going to talk about. Some are more on the hardware side. So they have the creation of the product as well as maybe a software component. Some are pure service businesses. And then there's everywhere in between. And some really don't even have, or at least one that I could tell doesn't even really have a pure kind of traditional technology component. It's technology in that it's innovative, but it's not pure technology. So what was really tough about this particular topic was, how do we find a way to kind of tie it all together for everybody and make a session that's useful for everybody. So I'm going to do my best, but what I'm going to suggest to those of you who are in attendance is, in this particular case, I'm totally fine with asking questions in between and maybe guiding the discussion there. I have a number of slides. Some of them are pretty specific. We don't necessarily have to go through every single one of those. If we sort of see that you guys have a bit more of an interest in asking more general questions relating to contracting for a business, I'm totally happy to do that as well. So just kind of wanted to give everybody the heads up about that. Okay, so I'll do a screen share now, just to kind of guide the discussion. Of course, my email is right there. Everybody see the screen here?
Yep, looks great.
Okay, good. Okay, so the way we want to approach it, again, as I mentioned, tough topic, but I think the way that we want to approach it is to say that first we're going to talk about the importance of contracts, then lead ourselves to how we can kind of categorize some of you guys into types of startups that can bucket you into the different types of contracts that you may require. And right away, you'll see that for a lot of you, there's going to be a focus on the actual creation of that product or that offering that you're creating. And then afterwards, it's the licensing of the selling of that product. For those of you who are on the service side, you'll see the way that services are typically offered and identified in various services agreements. Okay, so the first thing is, why do we even have contracts? What are contracts? Why can't we just make a verbal agreement with whoever it is that you're going to be doing work with and say, this is what I want to do, this is what you want to do, this is how much I'm going to pay, etc. Well, the obvious reason, I think, is because contracting really forces us to do a couple things. It forces us to think through all the relevant considerations that are necessary to, or that relate to that particular commercial relationship. And then once you've thought about all of those considerations, it allows you to make decisions on those considerations as between the parties, and it's hopefully evenly negotiated. And then you articulate those decisions in something that is written and ends up becoming evidence about what you agree to. If you didn't have a written contract or a clear, unambiguous contract, then if you got to a point down the road where there was a dispute between the parties, it could lead to ambiguity. What did we mean? What did we intend? Which brings about a tremendous amount of risk. For startups in particular, what I like to explain as well, that's a real big importance for having clear and unambiguous contracts, is that it could really prevent you from success down the road. Startups oftentimes need to have clear contracts that are then presented as part of a due diligence process. If you're going to get investment into your business, or if someone down the road wants to acquire you, one of the first things they're going to look at is they're going to send you a due diligence checklist and request your material contracts and see how you are contracting with your parties, whether it's license agreements or services agreements, whatever it might be. And they're going to want to make sure that there's clarity, that there's an understanding about what it is that you're contracting for. So there's real risk if you don't contract correctly. Even if there's a perceived risk, it could lead to an investor or a potential acquirer having a potential issue with you. I'm identifying here in the slides as well some other pitfalls that we see when we work with startups. We know that budgets are extremely limited, that a lot of startups bootstrap, and the sense that we get is that not all startups apply the same level of importance to contracting that they do to, let's say, product development or research and development. They put all of their budget into the creation of their product, and sometimes not enough on the organization of their business. And we were referring specifically to your legal, your financial, et cetera. And on the legal side, that often leads companies to try to save by trying to pull some online template that they see that they think is applicable to the nature of their business. And so we're identifying here in this slide some of the concerns that you might have there. The reality is that it has taken lawyers years of experience and expertise to try to figure out what legal considerations are applicable to a particular situation. Just because it may seem like two offerings are similar, they're not necessarily similar. And oftentimes it really requires someone to truly evaluate the offering and determine whether or not there's particular legal considerations that need to be addressed. So I think that's a major risk with using online templates. The other one that we see that is a massive risk is that you're pulling an online template from a business that resides in a different jurisdiction. So it's completely drafted incorrectly for, let's say, Canadian startups or Ontario-based startups. Plus, the law really evolves over time. So if you're pulling a template from a particular point in time, it may not be enforceable. It may not be up to date. It might not be compliant with what it is that you have to prepare for the nature of your business. So it's just some examples of why it's important to contract correctly and clearly. And as I mentioned up front, honestly, the hardest part, I think, for this particular discussion, and I'm hopeful that you guys still, are able to get something good out of it. But the hardest part was all the startups that are on this call right now have really varying profiles. We asked for the profiles in advance. We looked at your businesses and we tried to find commonality. And really, the startups can range in terms of whether or not you fit into one of these categories. But generally speaking, what we find when we're working with startups is that there's at least a component of the business that falls into one of these profiles. The startup either is building and offering some sort of software product. For example, it's a platform or a mobile app or some sort of game or something like that. They are developing, creating, manufacturing some sort of physical product or hardware, or it could be some sort of unfinished material. I know on the call, I hope the attendee is here. One of the attendees is has a driveway material that would fall under this profile as well. And then the third is some sort of consulting business, some sort of service-based business. So I gave some examples here. It could be a healthcare consulting firm, a data consulting firm, cybersecurity, et cetera. And then very often you have businesses that really fall into more than one of these categories. So you might have, a business that really has a very high touch service, but is enabled by software or is facilitated by software. You might have a hardware business. Let's say, for example, you're coming up with some sort of drone that you've manufactured a product, but you also have to develop a software as well, or leverage a software as well that is included. So oftentimes the businesses fall into one or more of these categories. What I wanted to do, if this is at all possible, even with a show of hands, and I'll kind of scroll through, is to ask, if you guys, how many of you sort of identify as a software business? If you could just a hand raise. I see Yuri, I see Jennifer. Well, now the names are blocked, but there's a number of you that I think are considering yourself software businesses. What about more of like the physical product hardware business? I don't see any hands, but I think there were based on what we saw. What about more of like a service business? Okay, and I think some of you are really raising your hand twice there. So obviously there could be service components, there could be software components, etc. So what I'm going to try to do is tailor the discussion. Okay, Carlos says we are SaaS. Thanks, Carlos. What I'm going to try to do is tailor the discussion initially to those that are building products. And then towards the end of the discussion, we'll talk more about those who are sort of only providing services. So again, I apologize in advance if there are components of what we're going to be speaking about that are not 100% relevant to every one of you. Bear with me, and by all means, ask questions if possible, and I'll try to answer them throughout to guide the discussion. If you are a product business, and what I'm referring to when I say a product business, I think it includes the creation of software, or even quite frankly, the white labeling of software. If you're sort of leveraging and customizing some existing software and then reselling it, that's a form of a product, in my view. If you are building a physical product, or white labeling a physical product or hardware, also a product, because the nature of what you got to do for those types of businesses is quite similar. You first have to create the product and deal with the contracts associated with the creation of the product, and then once you have built it, you could be in a position to offer or license or sell or distribute that product. And so I'm making a distinction between the nature of the contracts on the building side versus the nature of the contracts on the offering side. And you'll see there is similarity within these buckets, regardless of what type of business you are, so long as you're a product-based business. And so for those who are developing software and hardware, oftentimes what we see is that you have a founder team, anywhere from 1 to 4 or 5 people that are typically the founders. And when you have a larger founder team, very often one or more of the founders is sort of tasked with being the product manager or the product creator. On the software side, it could be the CTO level type of person. On the hardware side, maybe it's someone who's the inventor, the engineer, whatever the case might be. And so they're often tasked with building what we call a POC, a proof of concept, or an MVP, a minimum viable product of that initial product. And the idea is you want to build something that kind of proves the concept, that says, we think that we're solving a problem. We think that we have built something that is of use. My light just went off. Give me 1 second. There we go. Maybe past the initial POC or past the MVP stage, that founder team decides that, okay, well, in order to build the next iteration of that product, we really have to decide who else is going to help us in our product development. And we see that this happens in one of a few ways. It either happens by hiring employees, so we mean actual employees that are brought onto the team, or sort of quasi-employees, or let's call them part-time engaged people, which we call independent contractors. They're not quite employees, but they are, you're trying to make them almost as if they're part of your team. And the last option is we do see some startups fully outsource to some sort of domestic or foreign agency that helps build that product through their services, and it's usually identified in the services agreement. So as you could see, there's a number of different scenarios that could occur when you are in the process of designing and developing that product, and all of these have different contractual requirements, but with some similarity. Okay, so for the founders themselves, if you've built your product, whether it was before you incorporated or even after you incorporated, the idea is that whoever is the creator of that initial product, that software, that hardware, whatever it is, The law, the standard position is that the law would say that whoever's the creator is the owner of whatever it is that they're creating. And particularly when it comes to software or other forms of intellectual property, including something like hardware that may have patent rights or that may have other design rights, you want to make sure that the founders are assigning that intellectual property and the ownership over to the company. Why is this extremely important? Well, first of all, you don't want to have a dispute amongst the founders as to who actually owns this product that you're creating. If you're building this product, it should be owned by the collective, by the company. And then further, if you have investors or an acquirer, they're going to want to make sure that the company is the owner of whatever it is that you're selling, the owner of the intellectual property. And the same goes for if you're hiring employees, if you're hiring contractors, if you're hiring a service agency. Probably the most important thing to clarify in some sort of agreement, in what we call a founder engagement agreement, an employment agreement, a contractor agreement, or a service agreement with a service agency, I think is the ownership of intellectual property. It's probably the most important thing that you want to deal with as a startup. Yes, there's a number of other things that you'll want to deal with in these agreements. Primarily, what is the nature of the service or role or obligations? How much are these people getting paid? What is their compensation beyond cash? Maybe employees, contractors might have a option component or some sort of equity compensation. But so you really are kind of clarifying the entirety of the relationship. But if you're going to take one thing out of this conversation, I think the primary most important thing is whatever intellectual property is created by founders, employees, contractors, or service providers that are building the product, it should be clear in your contracts that it is to be owned by the corporation. Okay. The other real nuance that it happens between, let's say in particular employees and contractors and independent contractors is there's a real pitfall with employment law. Employment law is one of the trickiest and also quickest evolving areas of the law. Each province in Canada has its own employment standards legislation. The employment standards legislation really is there to protect employees. It's there to say, at a minimum, employers will give employees a certain minimums, minimum pay, minimum vacation time, minimum protections, etc. And one of those protections that I think is for employers is the one that you have to be the most aware of, is that if you want to terminate an employee, you have to do so in accordance with A, employment law, B, what's written in your employment agreement. And you can't have your employment agreement be less than the minimums under employment law. So it really creates a requirement that employment agreements are drafted very, very carefully so that they are enforceable and so that they are not under the minimums that are offered by employment standards law. The other thing that becomes extremely important is that if you intend on hiring a non-employee, so a contractor, it's got to be very clear that they are a contractor and not an employee, because if you accidentally make one of your contractors an employee, then they could end up having the benefit of all of those minimum employment standards, including that they get a certain requisite amount of notice prior to you being able to terminate them. And whether or not someone is a contractor versus an employee is a question of fact. So the contract itself is one of the factors that a court will look at. So if you call someone a contractor and you have them sign up to a contract agreement, that is one of the factors. It is not a determinative factor. We look at a lot of other factors, including whether or not that person had control over their own time. Were they taking on work from, other parties? Did they use their own tools, etc.? So it's important to know the distinction of what is an employee, what is a contractor, what did you intend? Because it can make a very large difference for you in terms of the setup that you have with that particular person that you're engaging. It can also make a very big difference in terms of what you are eligible for, with respect to certain grants and shred opportunities. I don't know if you guys have had other sessions relating to grants and funding and things of that nature. I'm trying to continue to scroll through to see if people are nodding, but so there are real distinctions there as well. Some grants are only available to employees. The shred, if it's applicable, is available at a much higher degree for Canadian employees than it is for contractors. Contractors, you still can apply some shred if you guys are familiar. Everybody know what shred is? I'm just gonna, again, some people are nodding. Does everybody know what it is, or does anybody want a brief explanation? Yeah, I don't see any questions. I see some thumbs up. Basically, it's tax credits that are offered to innovative companies for research and for scientific research and development. And so if you have employees that are employed for that specific purpose and you qualify, and there's a number of criteria that you have to meet, then you could potentially get some tax credits, basically giving back some of the money you spend on salary. Really, really valuable. And then we've listed some of the other important considerations, but just to kind of move past that, those are some of the important things to consider when you are actually building the product that is a software or hardware product. If you are more on the hardware or physical product side, then it's also possible that you might have come up with a concept, but you really are going to rely on some outsourced manufacturing relationship to actually build that product for you. So, you know, again, if it may apply to some of you, I know for sure it applies to some of those that have built hardware or physical products. You don't have your own factory necessarily as a startup, so you're going to definitely rely on manufacturing relationships. It's also possible that you've built a business that is not necessarily a brand new invention, but you're putting your own spin on some sort of existing physical product. You're going to brand it in a particular way. You're asking for it to be made in a particular way. So that is less manufacturing and more that you are obtaining the rights to resell this physical product and brand it in a particular way. And we call that a white label reseller agreement. So in these situations, again, contracting, super important. Particularly if you are very reliant on a specific manufacturer or on a specific owner of a product that's going to permit you to resell. Really important for you to have clear contracts. What if that manufacturer gets the idea from you, but then starts manufacturing for a number of other buyers? Should there be any sort of exclusivity in your relationship with them? What if you came up with the concept, but then and with the IP, let's say, and with the invention, but you just want that manufacturer to actually build that product for you and use just the manufacturing component there? Well, then the contract would be the one that really identifies the ownership and the licensing of the intellectual property. Maybe you really want them to keep your product or your trade secrets or your concept super confidential. So that becomes important considerations to have. And even before I go through the remainder, I will be honest, when you are utilizing, let's say, a foreign manufacturer, something that's offshore, overseas, the debate comes up about enforceability of these contracts. How easy is it for you to even enforce a contract that you have with China or somewhere else? And I think it's a valid question. There are ways that you can enforce contracts in other jurisdictions, but it would be difficult, particularly for a startup that doesn't have a ton of resources. But my response to that is that enforcing a contract is not the only benefit to having a contract. The other benefit that we mentioned early on is having a clear and unambiguous understanding of what the parties intended. So most people, despite what we might think, really just want to have good commercial relationships, and there's other components, goodwill, reputation, etc., that people want to uphold, and having clear and unambiguous contracts allows you to sort of rely on, well, this is what we said we were going to do, so let's just do what we said we were going to do, and it often resolves a lot of disputes just by being able to point to those unambiguous contracts, even if the actual enforcement, if there was a real, sort of litigation that arose as a result of the contract, would be difficult or costly to enforce. So I think it's an important point that I wanted to mention. You see there's other really important considerations we'd have in the product. in the product agreements, the warranties, who has responsibility for product liability or IP infringement, the regulatory requirements, et cetera. So a lot of considerations to think about when you're having those types of agreements. I want to pause there for a second just to see if anybody has any questions so far before we move on to offering the product and sort of licensing or selling that product. Any questions so far? No, everybody good? Okay, so admittedly, the next few slides are a little more skewed towards the software businesses. So for those of you who are not on the software or the hardware with software side, I think, I don't know, go get a coffee or something like that. But the stuff that we're going to talk about is a bit more specific to that. So I mentioned, and I'll kind of go back to it just to remind you, we first build the product. And then once we have that product, how do we offer it? How do we license it? How do we sell it? So if it's a software or a hardware that has a software component, it will be done by way of a licensing arrangement. And then you'll see later on, if it's more of just a physical product that doesn't have a software component, then the sale is more of a distribution or a direct to consumer sale. So we'll get to that in a second. Well, when we talk about licensing software, the types of agreements vary dramatically. And I think this is another factor that leads me to really be convinced that it's very hard for startups who are not built by like, let's say, expert technology lawyers to determine what is the appropriate contract to pull from a competitor or whatever, or from a similar business. It's very hard because there are a number of factors that affect the way the contract should be drafted. And even there's a number of factors that I think affect the style and the presentation of the contract. And what we found is that these four factors are primary things that we would look at to see what is the style and nature of the like, in particular, a license agreement. And so the first is the software offered as a perpetual license, so something that you can pay for one time and keep forever, or is it something that is offered as a service, a software as a service? There was a couple of you that responded in the chat that you are software as a service businesses. So that's one major consideration. The second is your startup offering this software under some sort of negotiated business to business license, or are you making it available directly to a user? And that user could be the first user of a business, but it is just directly offered to a user. I'm giving some examples in these ones here. So for example, a direct to user software could be something like Instagram. You just download it and you agree to a terms of use and off you go. Versus something like a Salesforce, where there's an order form, you got to negotiate a license agreement. Might not be able to negotiate much of it, but it's still something that is requested and that you agree to as part of an order form. The third is something that we'll get into in a second, what we call low touch versus high touch onboarding. Can the user just by themselves sign up for your service, put in a credit card, be ready to go? Or do they really need a much more guided approach to onboarding onto your software? And we can give some examples there about that afterward. And then finally, this is becoming less relevant nowadays because it seems like all software is cloud-based, but it's still relevant to know whether or not your software is what we call hosted. Hosted meaning it is software that is installed on a cloud server, let's say, that is accessed through a browser or an application, etc. Or is it installed? Is it old school? I'm going to take a CD or a DVD and put it into my computer and run an execution file to install those files locally on my computer. So those are the main factors I think that really affect the nature of the license agreements that you would offer. It's pretty technical, and I don't want to go too far if we don't have to. But so please feel free to ask questions. but I'll try to go through these a couple quickly. I see there was already one question that was saying, can it be combined B2B and direct to user? Does it matter for the licensing contract? The word B2B is maybe a little bit misleading. A lot of direct to user softwares are business to business software. It's just the nature of which you sign them up. It's not like there's an authorized representative that is physically signing an agreement or signing a DocuSign. In direct to user, the idea is that there would be like a sign up button on a website that allows you to put in some information. So the answer to that I would ask there is that it definitely can be a direct to user but B2B platform. And then you say our software is to hospitals but can be sold to individuals, physicians, in the hospital. If the software is for hospitals, typically you would sign up someone who can represent the hospital, and then those people would add the individual users under that software. So we can get to specific examples, but it might be clear once we look through these factors. SaaS versus perpetual license. For sure, a lot of you who have software would have heard these phrases before, but the primary difference is that in a SaaS, it's more of a subscription model. It's a per seat or per user monthly or annual fee. And it includes all of the updates relating to that and support relating to that software. So it's not like there's versions. There's not a version 1 that you pay for, or a Microsoft 2010, and then you got to buy the 2012 and then 2014. It's you get the access to Microsoft 365, and it just regularly updates, and you're paying throughout a monthly or annual fee. The perpetual license was an older model that still exists for a lot of people, where you're paying an upfront fee that is oftentimes a lot more upfront, but it ends up being a lot cheaper than a subscription model afterwards. And for a perpetual license, the only real way to continue to have ongoing maintenance and support is by paying for separate support agreements afterwards. So you probably have like a 12-month warranty with that perpetual license, and then afterwards you got to kind of pay to keep up that warranty. The B2B versus direct to user, again, what I mean more here is the negotiated contract versus the take it or leave it type of terms of use here. So this is like a real big stylistic distinction that you'll see that's pretty dependent on the nature of your offering. For a lot of direct to consumer or direct to user type of startup type of software businesses, it doesn't make sense to have contracts that are negotiated individually with each user. So you really want to present it as a take it or leave it type of scenario. And so you allow the user to have the ability to just sort of accept the terms of use. If it's a business software, you're allowing that first user to become a super administrator, who then has the permissions under the software to add additional users. So that's more on the right side. And on the left side, it's someone who has the authority on behalf of the company is going to really try to negotiate that contract with you. So if you are the startup that is offering the software, you got to figure out, which one do I fall into? Is it more likely that I'm selling to enterprise clients that are going to really want to negotiate these contracts? Or am I selling to that smaller business or that individual consumer that I'm going to really impose my terms on them? And it's dependent on the nature of your business, the nature of your offering, the leverage you have, etc. We talked about, I mentioned the phrasing low touch versus high touch onboarding. We had, like, when I was looking, we had a couple examples here. I think AdMass, I don't know how to pronounce it, Inverse. Those to me are low touch onboarding platforms, because there seems to be an ability for the initial user to just go on, put in their credit card information and provision their own account, and then add additional users afterwards. Low touch, often used for SaaS, and then you really want to try to give a lot of the support tools to your startup for them to self-serve. So knowledge base, tutorials, YouTube videos, that's a really low touch onboarding. They can do it all on their own, and you spend more money as a startup kind of like building the low touch self-serve component upfront, but then you save by really not having a lot of the hand-holding afterwards, versus the high touch where there really has to be a much more like guided approach to onboarding. From what I can tell, it seems like PledgeX, Magnify Access, those ones from the cohort seem like they're more high touch to me based on what I can tell so far. So, might require professional services to onboard the user, might require customization, configuration. The company might have to manually provision users on the platform. So that's more of a high touch, approach. There might be training that you have to offer, etc. And then lastly, the one that we'll just sort of look through quickly, I think the easiest way to explain it is Microsoft Exchange email back in the day, when we had servers in a server room and certain applications were installed on those servers. That's what we call on-premise. It is sitting on your premise. That software is hosted on your premises, on a server on your premises. Hosted is, Microsoft 365, Google Apps. Those are hosted cloud-based softwares. How you sign up for them are more like, clicking to accept an agreement, like we said beforehand. And the last one is sort of the desktop software, Microsoft Office 2016. You put that CD in your computer and you install that software. So really, different ways of offering software that could significantly affect the way that we contract for them. Again, I want to pause there. That was a lot of software stuff, not necessarily applicable to everybody. I think it is applicable to those that are in the hardware business as well, that offer hardware associated with that. Sorry, software associated with that hardware. I think it's also applicable to service businesses that utilize software in the provision of those services. So there's a lot of complexity there. One thing that I forgot to mention, but I think I should mention it, is the nature and style of your contracts when you are in that hybrid approach where you are, part software, part physical product, part service. Generally speaking, the rule that I think that I like to apply is that whichever business model is your primary business model, that is the way that your contracting style will be. So if you're a service business that happens to be enabled by software, you're primarily going to offer your services through a services agreement, not a licensing style agreement. If you are primarily a software business, but you might have to offer some professional services or customization or configuration services, you're probably going to offer it in some form of a license agreement that has some service language contained. So the style of agreement that you use is often dependent on what is your primary business model, if that makes sense. Okay. Any questions so far on building the product, like getting a design developed, created, manufactured, or on the offering or licensing of software related products or products that contain software? Any questions so far there? I hope the lack of questions is because it's extremely clear and no one has any follow-up questions, and not because everybody's completely lost. Please tell me if so. Okay, so we talked about how you offer software products or products that have a software component. But how do you offer products that are physical but don't have a software component?
Hi, Allan.
Yeah, please.
May I ask a question?
Definitely.
So the focus of this so far is us giving a contract to a client. Will you go into us going into a contract with a supplier as well? Because that would be of interest to me in negotiating those kinds of contracts.
So a supplier, I think, we did admittedly briefly touch on supplier contracts. I think this would have been the slide where there's a supply component here. What is the nature of your business, Jennifer?
I'm inverse. So we have the low touch. You're right on that. We have the low touch software as a service company, but I do have contracts with a lot of other suppliers.
Sorry, a lot of what type of suppliers?
Other suppliers, like suppliers for data and that type of thing. And I don't know that it would really fall under a white label, but
no.
maybe.
So that admittedly is a very unique situation. So a data supplier is really like they would be licensing data to you. So the form of agreement that you would be using in that situation is you have an owner of a data set. Okay, so in that case, there's an owner of a data set. that is going to want to have a contract with you to license that data set to you. And so the nature of the agreement you use in that scenario would also be a license agreement. It would just be not that they're not licensing software to you, they're licensing a data set to you. And in their license agreement, the primary things they're going to want to care about is identifying that they are the owner. They're going to want to identify they're the owner, and you're going to want to make sure they identify that they're the owner of that data set and that they have the authority and the right to license or sub-license that data to you. And then for that particular type of agreement, you're going to want to make sure that you understand whether or not there are any license restrictions to your use of the data. What are you allowed to do? What are you not allowed to do? Are there any usage limitations, sub-licensing restrictions? Is it only during a term? Is it perpetual? Can you commingle that data with your data? Who owns the commingled data or the derivative data? So there are very specific things that you would want to know in that particular situation. It didn't quite fit into what I thought was the order of this, but I'd be more than happy to talk with you about that privately afterwards.
Okay, thank you, Allan.
My pleasure. Anybody else before we move on to kind of like offering physical products?
I have a bit of a question with regards to the agreements, if that's okay. So we're a SaaS company, but because of how the advertising industry works, and we often work with agencies, there's kind of like a standard of having an agreement as well. And it outlines certain beginning and end of the campaign, because we're not kind of a traditional SaaS model where it's a subscription based. It's more of a usage based. And right now we're still in the process of figuring out how to consistently have them use our product. So often it's like a Christmas campaign. So the campaign begins A, ends B, and contracts are a way for us to lock them in on the budget. For example, like right now we're locking somebody in for a budget for March next year. So it's beneficial for us to have these contracts. But I've heard something where you can streamline contracts via like master sales agreements. So if you're dealing with, for example, one agency, we have one agency, it handles about 5 different brands, and we're doing campaigns with each of those brands right now in the following year. So does that, like, how would that happen? I guess, because we did one campaign with one brand, they were really happy, and we're trying to make it as easy as possible for them to onboard more brands. So it's very friction-free and preferably saves us legal fees as well.
So the next slide, and there was one in between, but the next slide that I was going to get to afterwards was, it sounds like your business is actually a service business, and it sounds like the nature of what you're offering is like, am I wrong? Like PPC campaigns, pay-per-click campaigns, that sort of stuff. Like, do you manage AdWords? Do you do things like that?
No, so we have a technology, it's an AI platform that we've developed. It's like a PPC, but for influencer marketing. So it's actually, we don't use any external like Google or anything for our clients. We don't sell services. We sell our platform, but we lock them in via an agreement.
Okay.
So
for that, yeah, like it's like influencer, what's the word? Influencer, not engagement, but activation. Is it like activation of influencers, that sort of thing?
Similar. So like instead of using influencers, we use everyday consumers. So for us, for example, for an influencer, you might pay $5,000 or $10,000 for one influencer. With us, for that $10,000, you're going to get 1,000 posts. Yep. So it's very automated, and that's where our tech comes in.
Got it. Yeah. Very familiar. Yeah, we've dealt with like micro influencer activation, that sort of stuff beforehand. But basically, again, it's unique business models. Although we're trying to sort of bucket things into slides here, unique business models need to be looked at uniquely, and we need to evaluate what's the best approach. Most likely it is dealt with in what we're about to talk about here, which is a master services agreement. There could be a way that you can set it up as a minimum term. Like it sounds like what you're describing is that you'd want to have the ability for one or more order documents to be submitted to you, but subject to the same master agreement, so that you don't have to renegotiate the agreement every single time. It's just anytime they want to start a new campaign, they submit an order for that new campaign, and that order locks them into a particular term. That's most likely, but I'd have to learn a little bit more about your business to be able to come up with a solution for you. So just like I said to Jennifer, by all means, like reach out afterwards. I'll make sure that Tabitha gives the info and we can chat through your business exactly, and I'll tell you what I think during that call.
Sounds great. Thanks, Alan.
No problem. Just in the interest of time, I'll try to move past those last few slides, and then if we have more time, we'll go through some more specific questions here. Again, we talked about offering intellectual products, so software, and then how do you offer physical products? So generally speaking, if you have a physical product, let's say you are Heads Up, which I think hopefully is on the call here, and you have some physical product that you might want to sell to either distributors or retailers, then obviously once you locate those distributors or retailers, there's going to be some form of agreement that you enter into with them where you are now the supplier of that product to them. Instead of selling individually to a consumer, you're selling to a broader group, to a supply chain. And so that happens in the form of a distribution agreement or a retail sales agreement. Again, a lot of things that I don't really get into in these slides here that are very specific to those agreements, that also relate to IP, exclusivity, minimum term, minimum quantity, who has the responsibility of risk for things like product liability, how they're allowed to market, how they're not allowed to market, can they use their trademarks, can they not use their trademarks, a lot of specifics with these agreements. Sometimes the distribution company or the retailer will present you with their form of agreement, so it's not necessarily that you're going to be the one drafting the agreement and presenting it to a well-established retailer. But you still got to be in a position to understand the importance of negotiating those agreements correctly, understanding the risk with what it is that you're agreeing to, and making sure that you're protected in that way. What we're now saying also is really e-commerce opened up the world for people who sell physical products or hardware. So if it is a type of product that can be sold direct to consumer, and quite frankly, not even just direct to consumer, because I know that using the driveway material company, I'm blanking on the name of it, I apologize, storm flow surfacing, using the storm flow surfacing as an example, even if it was some sort of unfinished material, we know there are also other marketplaces, e-commerce sort of marketplaces for specific industries. So even if you're not selling directly to a consumer, you might be selling to another supplier, you might be selling to another manufacturer, you might be selling to whatever, through an online platform. So in that scenario, the nature of the contract's also a little bit different. It's more of a e-commerce, understanding the e-commerce terms, shipping and return policies, privacy policies, things like that. So if you're building your own e-commerce platform, you're going to have to be the one that drafts those agreements. If you are, or if you're selling on your own store, let's say, or your own Shopify store. If you're just offering it, then it's just more of like understanding the marketplace terms. And then this is what I was sort of alluding to beforehand. If you are, and I'm going to just kind of go back just because I want you to, now that we've seen it all, let's go back to those profiles, right? Let's talk about how we talked about software companies, we talked about physical product and hardware companies, could be in between. And then what about those service businesses? Again, service business could also have software component or vice versa, but now we're about to talk about as sort of the last thing is the service business here. Generally speaking, the way companies that are primarily service businesses offer their services, which are services are usually offered by people or groups of people. They could leverage technology, they could leverage software, but they're offered by people. They are generally agreed to in some form of a services agreement. Okay, the same way that if you hired a service agency to build your product, like we talked about in the beginning, they would present you with a services agreement. If you are the service provider, you're going to present someone else with your services agreement. And if you're the provider, you should be drafting your own form of services agreement so that you know what you are comfortable signing, so that you know what risks you are okay accepting, and so that the style of the contract is set up in a way that is appropriate for the offering that you're offering, that has the appropriate risk for what you're offering, and that also, quite frankly, gives as little, I think it was Yuri that mentioned this, as little friction as possible in your sales process. And so you see that there are kind of two common forms of how you can do this. The first is the real traditional way of doing this. We call it a master services agreement, the MSA, if you've heard that phrasing before. The MSA is where you negotiate and sign one very kind of legal looking document between yourself as a service provider and a client. And then every time that you want to enter into a new project with that client, you don't have to renegotiate the MSA. You just add another statement of work. And a statement of work is exactly what it sounds like. It is a statement that identifies the work that you are going to perform for that particular client. This style is pretty traditional. It sort of invites the negotiation of the legal terms, because what the document you're presenting looks like a long contract, right? So it has all the legal terms up front. And so when you're presenting it to your client, they're going to say, okay, well, I'm going to read this whole thing. The business terms are really just contained in the statements of work, the schedules, but the main agreement, they're almost like being invited to read the whole thing. So it is not a preferable style when the client is small, when you have a lot of leverage, when you really want to enter into these contracts super quickly, because it does kind of create friction. But it is the style that is more used for larger clients or for more traditional clients. If you're entering into an agreement with a bank or some big procurement division of a large company, they want to see an MSA. They want to have the ability to negotiate those legal terms. And so you're not going to be able to get away with presenting something as though it's take it or leave it, which is the alternative. The alternative is that and it's almost like just a little psychological trick, you flip it on them. So you say, okay, the services agreement is just going to contain the business terms. It's going to contain the description of what I'm offering you, the fees, the term, how long we're going to provide it for. And then we're attaching a schedule that is just our master terms and conditions. It's our standard terms, and we don't negotiate our standard terms. That's the second option, is you sort of create that presentation that you're only inviting the negotiation of the business terms. You're not inviting a negotiation of the legal terms, because the legal terms are the legal terms and you're not changing them. That's the presentation you want to give. So obviously you're not going to be able to get away with number two in scenarios where you're dealing with traditional parties who are not used to that style, or where you don't have the leverage, or where the business is large enough that they want to have the ability to negotiate the legal and risk related terms. So again, two different styles. And if you are a service provider, you should really spend time understanding what is the best method for you. And it's not the same for everybody. And it really has to be something that we have to think through. And sometimes we have some clients that prepare both, because they say, okay, well, if the engagement is or the nature of the client is this style, I want to use the simple version. If the nature of the client is a little larger, I know what they're expecting, so I'm going to give them the larger version. But as a service provider, you should have your versions of these documents that you're able to present. Specific things that are dealt with in services agreements, the key stuff is how do you warrant your services? How do you disclaim your services? So in other words, what are you promising it will do? What are you not promising it won't, that it will do? How does your customer accept your services? If you give them some deliverables, when can you deem that they've accepted those deliverables? What's the process if they have any issues with your services? What if they want to change the whole scope of your project? How do you address that contractually? What if your services also includes the use of pre-existing third-party or open source software or material? Who owns any new intellectual property that you create as a result of the services? How do we limit confidentiality? How do we distribute the risk? I know I'm going through these super quickly because I don't want to be too technical, and I'd rather give you guys an opportunity to ask questions, but suffice it to say there's important legal considerations that are dealt with in services agreements. In terms of the statements of work themselves, again, the statement of work, think of it as like a schedule that identifies the project. Sometimes we know the project in advance and we know exactly what it is that we're going to offer. We know exactly the nature of the services you're going to offer to your client or your customer. And you scope the whole thing. You have all the specifications relating to what it is that you're going to offer. You may even be able to offer a particular quote or a project fee or a capped fee. We call that a waterfall style of a service project. Whereas in other scenarios, you might just kind of work together with the client and kind of figure out what you need as you go. And so in that scenario, you might work in what we call weekly sprints or monthly sprints. We call that an agile style. Lastly, sometimes there's that kind of ad hoc, just we'll provide services on an hourly basis. So different styles of projects and services agreements. And obviously in statements of work, it's more about the business considerations. So what services and deliverables am I offering? You know, what's the timing or schedule of this delivery? How am I going to get paid? How much am I going to charge? And you know, a couple of these other items here. That's all I wanted to tell you guys. It was a lot of information. I am very, very open to your feedback now or afterwards about how we can improve this session, whether or not it's a session that we should do all together or separated or whatever the case might be. But I hope that you guys were able to at least get some insight that's relevant to each of your businesses. And then this is just a bit of a slide about us and what it is that we do. The main hope that we have with our firm that we think makes us special is that we really take founder-led startups from their formation from the beginning all the way through to exits of their company, including an M&A transaction or even a go public transaction, which is very, very unique for a firm of our size. So thank you so much for giving me your time and your attention and allowing me to speak to you guys. And I'll just open it up with the last few minutes just to ask if there's any questions that you guys have.
Thanks, Allan. That was really great, and I think very much valuable to our founders. Just keeping an eye on time. I know some people likely have an 11 o'clock, so if you do have to drop off, by all means. But we're happy to keep the room open if folks do want to chat a bit with Allan. If you want to connect with Allan on a one-to-one basis, you're definitely welcome to do that. You can find his contact information in your biz planner, and Allan and his team are listed under the preferred service provider vendors there. You can connect that way, or if you want to reach out to your program coordinator, they can connect you with Allan as well. So I'll stop recording, but you guys are welcome to continue the conversation if you're able to stay on the line.